Obama's answer to attempting to close Guantanamo? You don't need prisons if you kill people before they go to prison?
I hope not. Without more information about who it is that the administration is killing and on what basis, it's difficult to draw a conclusion on that question. But I think when you see the kinds of authority that the government is claiming in briefing papers like this, it certainly raises the question about to what extent this program, the drone program, is in fact a substitute for detention.
And as you said, don't they say, don't the documents say that they will kill someone if it puts U.S. personnel at risk?
That's right. I mean, I think that one of the really troubling things about the document is the way that it defines this phrase, capture is infeasible. Because once you see that phrase in the first paragraph, capture is infeasible, it sounds like a real restriction on the government's authority to use lethal force. But halfway through the memo, they redefine the phrase capture is infeasible to mean something more like capture is inconvenient. And once you redefine the phrase in that way, then you've opened up the possibility of the use of lethal force much more broadly. And again, it does raise the question of whether they are using the use of lethal force as a substitute for detention, and even if they're not, whether that possibility is open for another administration in the future.
Jameel Jaffer, I want to thank you for being with us, Deputy Legal Director of the ACLU, Director of the ACLU Center for Democracy. Coming up later in the broadcast, we'll speak with Dan Ellsberg, famous whistleblower from the Pentagon Papers. We'll also speak with Jacob Appelbaum, who just lost a case. He does not have the rights as a federal court to know when the government is taking his Twitter information or email information. Stay with us.
I've seen you in the markets, I've seen you in the streets, and at your political convention. Talking of your crusade, talking of your nation, and other things too terrible to mention. And you proclaim your Christianity, you proclaim your love of God, you talk of apple pie and mom. Well, I've just got one question and I want an answer. Tell me, who would Jesus bomb? Maybe Jesus would bomb the Syrians, 'cause they're not Jews like him. Maybe Jesus would bomb the Afghans on some kind of vengeful whim. Maybe Jesus would drive an M1 tank and he would shoot Saddam. Who would Jesus bomb? Battleships, I've seen you in the housetop.
Watching Me by Jill Scott. This is Democracy Now!, democracynow.org, The War and Peace Report. I'm Amy Goodman with Nermeen Shaikh.
A federal appeals court has ruled the government can continue to keep secret its efforts to pursue the private information of Internet users without a warrant as part of its probe into the whistleblowing website WikiLeaks. The case involved 3 people connected to WikiLeaks whose Twitter and email records were sought by the government, including computer security researcher Jacob Appelbaum and Icelandic parliamentarian Birgitta Jónsdóttir.
The ACLU and the Electronic Frontier Foundation, which represented the account holders, argued the subpoena violated their privacy rights and they should know why the government wanted their information. However, late last month, the court rejected a request to unseal all orders relating to the 3 individuals that may have been sent to companies other than Twitter. For more, we're joined by Jacob Appelbaum himself. He's a developer and advocate for the Tor project system enabling its users to communicate anonymously on the Internet. Jacob Appelbaum, welcome to Democracy Now! I'm glad we didn't have to subpoena you to get you here.
I imagine I'd have to know about it in order to show up. So.
Well, talk about this federal court ruling that came down 2 Fridays ago.
Essentially, we lost, actually, quite some time ago about the data being revealed to the U.S. government. That is metadata. And the government essentially argues that metadata is not the same as content. Therefore, they can issue an administrative subpoena, a so-called 2703D order, and this administrative subpoena has a much lower bar than, say, a search warrant. And it can also have a gag. In fact, most of them seem to have a gag. Twitter was able to unseal this so that we could begin to fight it. We lost, and it's quite sad. They received the data, but we appealed again about secrecy of docketing. That is to say that we believe that courts should have to keep accurate records of this type of an order and other orders like it. And we were hoping that we would be able to learn that there were other companies out there and that we would be able to challenge this phishing expedition.
Explain what happened to you. Why did they get your account, all your information in Twitter?
Well, I mean, many people from the government have said during detainments and other times in which they have confronted me that I should understand why this is happening. But the reality is that I don't understand why it's happening in a legal sense, at least until now. Now the government argues that I should understand that this is the case, and it's this case because it's as secret as a grand jury proceeding. And there is, in fact, a WikiLeaks grand jury where they have been pressuring people. In some cases, people have been threatened with effectively indefinite detention if they don't comply. That, you know, they let people know there's really not...
What does it mean to comply?
Well, if they ask them a question, they'll either forcibly immunize them or they'll threaten them with just detaining them without really explaining what will happen. There's a lot of pressure coming from a lot of different angles. So what the government is effectively saying with this ruling is that they want to have not just secret laws and secret interpretations, but no accountability. And this is something which I think is pretty scary. And I think we should have public laws, public interpretation, and public accountability. And this is what we see is more of the same. I mean, we see this with the targeted assassination, the indefinite detention, and NDAA, and this is just the Internet version of that, where they've decided they don't even have to get a search warrant, and I have no right to resist it.
So what do you think, what are the implications of this ruling for government surveillance, and what the limits are on government surveillance, if any?
Well, I think in the United States the gloves are off, and when I was here with Bill Binney last, I think he pretty much explained that this is the case.
The former NSA, National Security Agency.
Yeah, I mean, the secret interpretation of Section 215 of the Patriot Act seems to be that anything that the government wants is fair game without a warrant, and that's terrifying. And this seems to be the tip of the iceberg. As we know from that video with the FBI woman that I met, she seemed to indicate that there was a national security letter. So I think these 2703D orders, they're important to be considered as the tip of an iceberg of an investigation. So there are probably other types of legal orders. And so I think it's important to stress metadata in aggregate is content.
People are having trouble understanding you. Metadata in aggregate is content.
Absolutely. What that means is that if you look at one event that I talked to you via email, in theory that we talked is a piece of metadata. The content, that is what I wrote in the email, that is in theory protected and you need a search warrant for it. But if they know that I talk to you every single morning, that tells a story, maybe even a really important story. And maybe if they see that I talk to Dan or they see that I talk to other people, that also tells a story that is equal to content when it's viewed in an aggregate. And that's something that's quite terrifying because the court doesn't seem to recognize that, nor do they recognize the location privacy issues with